acting as a highway patrolman, an employee of the state of Minnesota. Wording is important. The defendant asked plaintiff to see his driver's license. The plaintiff explained that he is not a licensee under any board or commission and is not required to be a licensee. The defendant insisted that the plaintiff must have the said license. The defendant then arrested, searched, and handcuffed the plaintiff without warrant, and over his objection, the defendant's action in violation of the plaintiff's rights and the constitutional provisions of due process of law. Now, you can argue about whether he had to have a license or not. That's not the issue we're talking about right here. The licenses are issued by what?
Competent authority that gives you permission to do something that's otherwise illegal.
Issued by a competent authority, which apparently you aren't. A competent authority to give you permission, exactly right, to give you permission to do what is otherwise unlawful or illegal. We don't know. We just don't know how far that we are. We don't know just how many contracts we signed. The defendant, the defendant then arrested, searched, and handcuffed the plaintiff without warrant and orders him to act in violation of the plaintiff's rights and the constitutional provisions of due process of law. Due process of law. Keep that in mind. Keep that phrase in mind because that's an important phrase. The defendant gave no specific charges to the plaintiff for his being stopped or for the arrest, nor did he advise him of his rights as shown in the defendant's field report, the defendant being the police officer, which contained only traffic misdemeanor charges. A copy of this report and an official complaint were received by plaintiff 2 months after the arrest. The defendant brought the plaintiff to the Hennepin County Jail, where the defendant knew that the plaintiff would be subject to booking, which included fingerprinting, photographing, and confinement for an indefinite period of time, and possibly be subject to other types of assaults and batteries. Further, the plaintiff, by his own admission, made no attempt to bring the defendant before a magistrate or judge when he had full opportunity to do so, being that the arrest occurred about 10:15 a.m. on Wednesday. The defendant, acting on his own accord and without a warrant or court order, had the plaintiff's automobile towed to an impound lot and put it on a hold order. Okay, that's facts. That's pretty simple, pretty brief. Pretty brief. See, it doesn't need to be complicated. Most of the time it isn't complicated. They try to complicate things to make it look like you can't do anything. They want to say, that's why they say you can't fight City Hall. What do the lawyers say if you defend yourself? You're a fool for a client, right? Because you don't want to hire one of their bar buddies. Well, the problem is if you hire one of the bar buddies, you become a ward of the court, and you definitely are incompetent. Here's the count. Count one, false imprisonment. On September 30, 1992, the defendant, without warrant or due process of law, and he quotes Minnesota Constitution, Article 1, Section 7, unlawfully arrested the plaintiff and acting contrary to the law, did falsely imprison the plaintiff, depriving him of his liberty. As a result of the defendant's false imprisonment of the plaintiff had his right to liberty violated, suffered mental anguish, loss of time and wages of his work, and a discredit in his reputation by his failure to attend the scheduled meetings. In other words, he couldn't go to meetings. Count two, false imprisonment. The defendant, upon arresting the plaintiff, brought him to the county jail for the purpose of booking and detaining him, and by his own admission made no attempt to bring the plaintiff before a proper judge or court, as is required by due process. Another point, actually, in the due process scenario. The acts of the defendant in deciding how to deal with the plaintiff after his arrest and failing to take him to a judge or court so decide constitute false imprisonment by the defendant under the law of the land. They quote Minnesota Constitution, Article 1, Section 2. Count three, assault and battery. Well, isn't that an interesting count? Due to the unlawful acts of the defendant, the plaintiff suffered a series of assaults and batteries upon his person, including arrest, handcuffing, imprisonment, physically searched, forced fingerprinting, and booking procedures and harassment. And they can't do that. They can't do that for misdemeanors. Did you know that? They can only fingerprint you and take a picture of you because those are your property for a felony. Now, they do it because it's a matter of policy in the jail. It's policy. So, policy trumps law, right? Is that how you look at it? Is that how you see it? Not how I see it. I had a friend who, for purposes of the fact that this is an unlawful, I don't know what to call it, kind of acquaintance, that this is unlawful, they took him in for this, and after saying, "Well, grab your hand, you've ever been fingerprint, they'll grab your hand, we'll go over the thing." He started screaming and hollering, and the guy jumped back. What's that? He did it again, he started screaming and hollering again. He says, "Well, you know, if I didn't protest, what would it look like? If I just willingly gave it to you, then I volunteered." So, you know, I got to put up some sort of fight. So I'm just screaming, but you can't do that. And of course, they knew what was going on, so they just went along with it. But he got his protest in. Assault and battery, how can that be a possibility? Assault and battery, we'll find out. It is manifest. Let me read this. At common law and under the provisions of due process of law, such an arrest without a warrant cannot be made. Since the arrest deprived the claimant of his liberty by an act not pursuant to due process of law, the arrest is unlawful. And we're going to prove that before we get done with this. We're going to prove that in your mind and by the law of the land and by the decisions that the courts have made across this land. Due process is not determined by the legislature. Let that sink in, because we think that any time the legislature passes a law, we're subject to it. Well, ladies and gentlemen, be honest. They simply cannot pass an act of any kind that takes away our due process rights or takes away our liberties. They simply cannot do it. And any time they do it, we have action. It is manifest, and this is from a court case. This is from Murray's Leasing versus Hoboken Implement Company, 18 Howard 59 U.S. 272, 1855. It is manifest. It was not left to the legislative power to exact any process which might be devised. The due process article is legislated as well as on the executive and judicial powers of government. It was not a restraint upon us. The Constitution was written for them. And I'm not afraid to stand and tell you that the Constitution of the state of North Carolina, the Constitution of the United States of America, have nothing to say to me. They do not apply to me. It applies to the government that it created. That's who it applies to. And cannot be so construed as to leave Congress free to make any process due process of law by its mere will. That is the United States Supreme Court talking. Can't do it. The Constitution of Minnesota declares that no person shall be deprived of life, liberty, or property without due process of law. So does the state of North Carolina's Constitution. The words due process do not mean anything which the legislature may see fit to declare to be due process of law. And that's a quote from the State X. Rel. versus Billings, 55, Minnesota.